Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing day. Hey, so this is a Diddy update. So after my last update on Diddy, there were a number of filings that were submitted. The last filing that we went over was a letter from the defense counsel just asking to amend the protective order. And in that letter, it actually had a number of things that were addressed and brought to light, which shocked many of us. The letter pretty much covered the tapes, the freak off tapes that Cassie submitted to the government and they've had in their possession since December 2023. However, the government didn't release copies of those tapes to the defense counsel because it would have violated the protective order. They wanted to go ahead and protect victim one, aka Cassie, at all costs. So they offered for defense to schedule a time to come in and actually view the tapes. They did that. And after doing that, they felt that the tapes were not in relation to the charges that are being brought to or against Sean Combs. They went as far as to say that in the videos, it appeared that Cassie was dominant, that she didn't show any type of indication that she was being forced to do something. Just wild. They also requested that they get copies in order to have an expert come in and fix the audio and fix the video quality because the lighting was low. And to be able to have their defendant, Diddy, review these so that way he can prepare for trial. Hmm. That's it's giving sick. Okay, but let's hop right on into the documents that have been filed. And here we go. So this was the document that was filed on the 14th, shortly after I did the update on Diddy. It reads, and this is from the government. So this is the government's response to the defense counsel wanting to amend the protective order. So the government specifically submits this letter to request that the court direct that the defendant's January 14, 2025 letter motion to amend the protective order be removed from the docket and refiled with appropriate redactions that comport with the requirements of the protective order in this case. The motion seeks an amendment to the protective order related to certain videos that have been made available to consumption only and not electronically produced. In making this motion with incomplete redactions, however, the defendant has violated the protective order he seeks to amend. The video, which depicts sexually explicit content and nudity, are designated attorney eyes only by the protective order, subject to be carved out, making the videos available for defendant's inspection. Um, the protective order makes clear that the defense shall not share any AEO material or the content of AEO material with any other persons, subject to the carve out allowing for the defendant inspection of the videos. Further, attorney eyes only material is also designated sealed under the protective order, meaning that any portion of such material cannot be publicly filed on the docket unless it is filed under seal or the parties first confer regarding the seal designation. Under the protective order, no portion of the video should be filed on the public docket without being filed under seal or without the defense first conferring with the government as to the designation. Neither occurred. Instead of conferring in advance of redacting all content related to the videos, the motion blatantly violated the protective order when it left unredacted descriptions and characterizations of material designated attorney eyes only. This is no alternative reading of the protective order other than one, the substance of the attorney eyes only material cannot be shared with any other persons, and two, attorney eyes only material is otherwise designated sealed, meaning that it cannot be filed with on public docket While the public dissemination of attorney eyes only material substantially impacts the privacy and safety of victims, filing attorney eyes only material under seal in no way prejudice the defendant, as the full substance of the motion will be still considered before the court. The protective order thus serves to protect victims' interests and to prevent the defendant from, as he did here, selective and improperly disclosing evidence to the public in advance of trial. The government therefore respectfully requests that the court remove the motion and direct counsel to refile the motion with redactions that comply with the protective order. With this motion, the government also submits under seal for the court's review proposed redactions that comply with the protective order. After the motion was filed, the government immediately contacted defense counsel requesting that additional redactions be made in accordance with the protective order, and counsel responded only that they disagreed with the government's view of the protective order. Finally, the government respectfully requests that it is permitted to file its opposition to the motion within 2 weeks. That is January 28th, 2025, and the defendant takes no position on this request. So here that the court granted the court granted um, uh, the government wish, and that was to have to withdraw the letter that was filed with the defense counsel and have them redact it and then refile it. So this was the letter that was initially submitted. Now, well, not initially. This is what they redacted. Let me take that back. I'm gonna show y'all exactly what it looked like prior to that. Okay, so I'm gonna put these letters side by side if it allows me to do so. So this was a letter that was initially filed. You don't see many redactions. This is 7 pages, right? And let me just do this. I'm gonna do that. Go here. So here. So even if we look, right? So for instance, in this is the initial letter. This right here is the initial letter. I'm sorry. So this is the initial letter that was filed. So as you can see, we shouldn't even have known that there were 9 videos. So it was the descriptive wording that was used that violated the protective order. So they ended up redacting that first sentence. And then look at this. These videos unambiguously show that the person alleged in the indictment to be victim 1. So y'all pretty much named her. Not only consented, but thoroughly enjoyed herself. These are things that should not have been available to us. So you see? So it's very descriptive. And so then they went back. Y'all see the difference? Look, they went back and they redacted what they should have redacted in the first place. And the court obviously agreed with them for the simple fact they granted it. And that was the end of that. So the government had a right to do that. All right. All right, so let me get rid of these dockets. So that was there. The court said, yep, go ahead and redact it. This is the redacted portion from the defense counsel. Now the government responds to it. And they did this on the 15th. So we write in response to the government's letter requesting redactions to the defense January 14, 2025 letter motion. At the direction of the court, the letter motion has been refiled with the government's requested redaction. Nevertheless, we write in opposition to the government's proposed redactions as overbroad and inconsistent with the presumption of public access to judicial documents, and seek leave to refile the letter motion with narrower redactions. In my opinion, and I always say in my opinion, due to the nature of the case, I don't feel that it was overbroad and inconsistent because there's no reason why it should have been that descriptive. Yes, it is available because people like me and others who are interested in this case can access it from the outside. But as far as the protective order goes, it is in place so that the victim is not subject to any ridicule or anything of that nature. So you put out for everybody to see this narrative that she enjoyed it. She looked happy, she looked dominant, so on and so forth. That's a violation. How are you protecting a victim? Let me go ahead and read again. um as an as an initial matter, the defense general characterization of evidence did not disclose the content of the attorney eyes only material. A general description of the nature of the evidence with specific descriptions and additional details redacted is perfectly consistent with the language and spirit of the protective order. So they claim. This is especially true when the existence of evidence is already public and the government has regularly provided its own characterizations. So, what they're trying to say is that in the indictment, they already told us a little bit about what the tapes consisted of. And so they feel because the government did it, then they shouldn't have a problem with this letter being filed and certain information is, certain language is included in this letter. So in the indictment, the government stated that it publicizing extended X acts with male commercial X workers and elaborate and produce X performances that were electronically recorded. It also states publicizing that during the freak offs, alleged victims were subjected to physical, emotional, and verbal abuse, including being hit, kicked, and dragged, and that alleged victim claims are corroborated by videos of the freak offs. Even assuming the defense general characterizations of evidence without additional detail is covered by the protective order, which it is not, that is a not a valid basis for sealing. In determining if a document should be publicly accessible, a court should one, determine if it is a judicial document, two, determine the weight of the presumption of access attached to it, and three, balance the countervailing interest against the presumption of access. Because the motion to amend the protective order is useful in the judicial process, the presumption of public access applies. This is especially true where, as here, it relates to the government's key piece of evidence, and Mr. Combs' trial rights are being compromised by his inability to access it. What is so important that Sean Combs has access to the videos in its entirety? Because, mind you, in their letter to amend the protective order, they just felt that not only do they need copies in order to be able to, to clear the video quality or fix the audio, but for Combs to prepare for trial. Exactly why is it that you need those? Now I understand because they stated that they have to make copies and take still images because this is something that they might have to show in court. Blase, blase, blase. But will that really hinder him from preparing for trial? Hmm. Where did I leave off at? Indeed, the public can only have confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings if the documents on which judges rely on are publicly available. The presumptive right to assess prevails unless it is overcome by specific on the recording findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve aim. Let me see. The government's letter fails to address these issues and fails to provide any valid justification for sealing that would override the presumption of public access. Moreover, any competing justification provided by the government would not outweigh the presumption of public access and justifying sealing. While victim one may have privacy interests that justify keeping the videos themselves under seal at this stage, including details on the content of the videos, the fact that victim one was filmed while participating in these so called freak offs is public information. So I'm getting the feeling that if the government gives electronic copies to the defense counsel, somebody's going to leak those videos in order for us, the public, to formulate our opinion about Cassie. Because they in the previous letter they try to make it seem as if she was enjoying these instances, these freak offs, and that she was dominant and all these other stuff. They're trying to sway the public's opinion. Mm, 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 mm. Indeed, the government has publicized that these were extended X acts with male commercial X workers and elaborate and produce X performances that were electronically recorded. The indictment stated, and this is the government because they're the ones who submitted the indictment. It says that the government has publicized gratuitous details, including the use of baby oil, lubricant, extra linens, and lightning, room damage, and the delivery of IV fluids. The government also held a press conference publicizing the seizures of more than 1,000 bottles of personal lubricant and baby oil. And the government has publicly asserted that during the freak offs, alleged victims were subject to physical, emotional, and verbal abuse, including being hit, kicked, and dragged, and that the alleged victim claims are corroborated by videos of the freak offs. Faulting the defense for characterizing that same evidence as exculpatory and consensual is an unfair double standard and demonstrates the government's intent to mislead the public and the court. To accept the government's broad reading of the protective order would turn it into a tool to shield the public from any interruption or interpretation of the evidence that could be favorable to Mr. Combs after the government has been able to tout its own inculpatory interpretation. The result will be unfairly polluted jury pool manufactured by the government's misleading narrative and widely decimated by the press. This is nasty work. This is Mark Agnafilio. This is nasty work. So, in a nutshell, they're saying, hey, they did all of this. They already told us what the videos was all about. Why do we need to seal it now? Mm. Now, here is the government's response to that previous letter. It reads that the government respectfully submits the attached declarations in response to the court's January 3rd order in further support of its opposition to the defendant's motion for a hearing and other relief. Oh, this is okay. So this is this a protective order? I think they're talking about the protective order. All right. So at the request, oh no, this is in regards to I believe the search. Yes, this is about the search. Remember that the BOP investigator went into Diddy's cell and took pictures of all the, and I'm doing air quotes, quote unquote, attorney privilege documents. Okay, this is in response to that. All right. So it says, at the request of the Bureau of Prisons, the government respectfully seeks to file the declaration attached as Exhibit B under seal. Based, oh man, we can't even read their declaration. Aw. Based on communications with counsel from BOP, the government understands that the information contained therein reveals sensitive law enforcement techniques and reveals the identity of an employee involved in an ongoing BOP led investigation. And then they quoted a case, City of New York, where They stated among other interests, law enforcement privilege prevent disclosure of law enforcement techniques and procedures and protects law enforcement personnel and safeguards the privacy of individuals involved in an investigation. All right, so that makes sense. Finally, with respect to Exhibit A, the prosecution team declaration, the government provides information requested by the court, but in doing so, does not waive any applicable privilege, including law enforcement privilege and deliberative process privilege. Because, mind you guys, I forgot about this. The judge did ask for the government to submit to the court their reasoning for searching the cell, and from the government, the prosecution, as well as from the BOP investigator. So the VOP investigator reasoning is sealed. So we won't be able to see that, but we will see the prosecution's team response in regards to that BOP suite. So this was all right. So this was the BOP investigators. So we can't see it, and I get it. But I want to be nosy. But let's see why they did it. The government, the prosecution team. All right. All right. So this is the declaration. All right. So BOP's monitoring of the defendant communication in custody. So why are they monitoring Sean Diddy Combs? Based on my discussions with, and this is the declaration of Miss Christy Slavic. So, based on her discussions with the U.S. Attorney's Office and Southern District of New York Unit Chief, who directly supervises the prosecution team and the prosecution of the defendants, she learned that on or around or about October 10th, 2024, BOP personnel contacted supervisor and informed her that a BOP intelligence analyst had been monitoring the defendant's communications from the MDC and had found apparent attempts to circumvent monitoring, as well as the use of coded language and possible attempts to engage in witness intimidation. That same day, Supervisor 1 requested transactional data, example, the defendant's email and phone contact list and defendant emails from the BOP, and served the BOP with a grand jury subpoena for non attorney phone calls placed to and from the defendant. So, no, so any of the calls that were not to the attorney, they requested. They actually, not even requested, they subpoenaed it. Since that time, I have been the member of the prosecution team primarily responsible for liaising with the BOP, including Investigator 1. On or about October 13th, 2024, she spoke with Investigator 1, who provided an overview of some of the defendant's calls that he had monitored. Investigator 1 also detailed the unauthorized methods of communication the defendant was using, including using other inmates' PAC numbers, using three-way calling, and using third-party messaging service. I spoke with Investigator 1 on several occasions in October and November of 2024. Hmm. Planning for the MDC suite. Based on my discussions with another USAO SD&Y unit chief who does not supervise the prosecution team or otherwise have involvement in the defendant's prosecution, we're going to call that Supervisor 2, I have learned that beginning in or around June and July 2024, prior to Diddy even being in the MDC, keep that in mind. The BOP and the United States Department of Justice Office and the Inspector General began planning a large-scale search of the MDC for contraband. The BOP and DOJ OIG, who were responsible for the execution of the MDC sweep, hosted a series of status calls with participating federal agencies, as well as representatives from the USAO, SDNY, and the United States Attorney Office for the Eastern District. So, for the Southern District and the Eastern District, the supervisor was present on both of those calls. Based on my conversations with members of the prosecution team, I have learned that no member of the prosecution team was involved in planning of the MDC sweep. Further, as described in paragraph 7, prior to October 28, 2024, no member of the prosecution team was aware of the MDC sweep. So, it was planned prior to Diddy going to jail. The actual sweep, October 28, 2024, November 1st, 2024. Based on my review of email communications, I learned that on or about October 28, 2024, the BOP and other federal agencies began executing the planned MDC sweep. That day, after the MDC sweep was already in progress, members of the prosecution team learned of the MDC sweep when Supervisor 2 sent an email to all assistant United States attorneys in the criminal division of the Southern District of New York, and they did that via email. The office-wide email informed AUSAs and that the MDC sweep was a pre-planned, large-scale search of the MDC in response to persistent contraband issues at MDC. It further stated that the MDC sweep was not the result of any specific intelligence or threat. I also understood from the office wide email that it was expected that contraband such as narcotics, weapons, electronic devices could be seized from the USAO Southern District of New York defendants during the MDC sweep, and that the AUSAs, yeah, may be contacted about the contraband seized from defendants in their assigned class cases. Based on my conversation with Supervisor 2, who, as described above, is not part of the prosecution team, but had a role coordinating with those responsible for planning the MDC sweep. I have learned that MDC sweep continued through November 1st, 2024. Supervisor 2 was at the MDC on or about October 28, 2024, and on or about the morning of October 29th, 2024, to ensure legal issues involving the USAO Southern District of New York defendants were addressed, and to relay the message to the AUSAs for the Southern District of New York prosecuting defendants from whom contraband had been seized. Based on my review of public reporting, I am aware that on October 28, 2024, various media outlets reported that there was an interagency operation at the MDC where Sean Combs, the defendant, was housed. I think they said authorities launched intra-agency operations at federal jail in New York, housing Sean Diddy Combs. And so that's what our article from Associated Press published. Based on my conversations with Supervisor 2, I have learned that on or about the morning of October 29, 2024, following the completion of the first day of the MDC sweep, representatives from BOP, federal agencies, and the Southern District New York, Supervisor number 2, and the Eastern District of New York met regarding the ongoing execution of the MDC sweep and discuss various issues that had arisen, including the amount of time that the search was taken and a potential search of a unit located in the east building of MDC. Unit 1 is a general population, uh, wait, Unit 1 is a non general population unit where the defendant, along with other inmates, is housed. The agencies conducting the search inquired into, among other things, the position of the USAO, Southern District New York, and Eastern District New York regarding the potential search of Unit 1. Supervisor 2 responded that he had understood that the MDC sweep would include searching Unit 1, but that he would confer with the senior leadership at the USAO Southern District New York. Based on my conversations with Supervisor 1 and 2 and my review of communication, I have learned that on or around or about October 29, 2024, Supervisor 2 informed Supervisor 1 that the sweep was of the west side of MDC, which taken longer than expected, and was unclear whether the east side of the MDC would be searched. Supervisor 1 informed Supervisor 2 that, in her view, the MDC sweep should include the east side of the MDC as planned, in part because of the prosecution team had learned regarding the defendant's conduct at MDC. At the request of Supervisor 2, Supervisor 1 conferred with the USAO Southern District New York senior leadership about the search of the east side of the jail. This conversation included in substance that the sweep was taking longer than expected and did not include discussion of the defendant. Thereafter, Supervisor 1 related to Supervisor 2 that the position of the USAO Southern District New York was that the MDC sweep should stick to the original plan to search the entire jail. Supervisor 2 relayed to other personnel present at the MDC in substance that the sweep of Unit 1 should proceed as planned. Based on my conversations with Supervisor 1 and 2, I have learned that no USAO Southern District New York personnel directed how the search of Unit 1 would be conducted or whether any particular area or bunk within Unit 1 or any particular inmate's position should be searched. In addition, no USAO SDNY personnel were aware that Investigator 1 would be involved in the MDC sweep. Other than Supervisor 2, who is not part of the prosecution team, no USAO SD New York personnel had awareness of the specific details of the MDC sweeps operational plan. So I guess there wasn't no set rules as to how they would search or where they would search. They just knew that they had to search all of Unit 1. So it wasn't something that wasn't secluded. So since Diddy is in cell number 1, I mean not cell number 1, but in unit number 1, he wasn't excluded, if that makes sense. Based on my November 3rd, 2024 communications with Investigator 1 described infra at 16, I have learned that Unit 1 on the east side of the MDC was searched on November 1st. Based on my conversations with Supervisor 2, I further learned that neither Supervisor 2 nor any other USAO SDNY personnel directed or was aware during the search of the Unit 1 that the defendant's bunk area and possessions would be searched in a manner inconsistent with the BOP's overall plan to execute the MDC sweep to locate contraband. So they're saving their butts because they were like, hey, whatever that investigator had going on, we weren't aware of that. It was not in the plan. We just knew that Unit 1 was being searched. Neither Supervisor 2 nor any other USAO SDNY personnel directed that any of the defendant's possession be seized or photographed or were aware of whether that had occurred until after the search of Unit 1. Based on my participation in this prosecution and my conversations with other members of the prosecution team, I know that prior to and during the MDC sweep, no member of the prosecution team communicated with Investigator 1 or any other BOP personnel or federal agents conducting any part of the MDC sweep about the search of Unit 1 until after it had concluded. In a nutshell, they had no clue that Investigator 1 was doing this. Point blank, period. um, the prosecution team's communication with Investigator 1 because they're trying to figure out what what was the prosecution team, the government's communication with the BOP and the investigator before, during, and after. And so they're telling us. So they knew that the MD sweep was happening. During the MD sweep, there was no specifics, but they had no clue that Investigator 1 was going to go above and beyond whatever he would. They don't even know why he was there. Well, they knew that they were participating, but he didn't. They're just thinking that there were no specifics. Like, who told you to go into his cell and begin taking pictures of his possessions and items? All right, so here's the prosecution team's communication with the investigator after the sweep. On or about November 3rd, 2024, following the completion of the MDC sweep, the prosecution team first became aware of investigators' one involvement in the MDC sweep through a phone call between Myself, not me personally, but the lady, I forgot what her name is. So whoever declaration this is, her, and investigator one. Investigator one informed me that he had spent time in defendant's unit and had checked the defendant's bunk area for contraband, including cell phones. Okay. Investigator one also informed me that he took photos of certain of the defendant's paperwork in an address book. Investigator one provided a high level overview of the contents of the BOP notes, including the defendant's plans to discredit possible witnesses and find dirt on people. At the conclusion of November 3rd, 2023 call, I requested that Investigator 1 send the BOP notes directly to the AUSA, leading the filter team, because that is the team that is in charge with reviewing material that may contain attorney communications or work product. By email later that day, Investigator 1 confirmed that he had sent the BOP notes directly to the filter team. Okay, so Christy Slavic, that's whose declaration this is. So the filter team was for the purpose of going through the material, and if it is, they determine what is attorney communication or otherwise. But the biggest question here, and I believe that the judge is going to still ask, why did you, well, we don't have access to the darn his stuff because it's sealed. Darn it. But that's the biggest question. So now my question is, why? Why did you, if you're participating in a sweep to look for contraband, electronic devices, and narcotics, why did you feel the need to take photos of the address book and papers with that? I mean, it's good, but by law that wasn't what you were supposed to do. So I'm very interested to see exactly what his reasoning for that was, who authorized him to do that. So this lady, she covered herself. She was like, "Look, we didn't have no parts of that. We didn't tell them to do anything of that. I found out, 2 days after the sweep has done of what he done. I don't know if he thought that he was going to get brownie points for getting this information. And the thing about this is, if it does find out that he wasn't even supposed to get that, that could be inadmissible in court. Phew, y'all." I don't know. So that was pretty lengthy, but we covered two things. The first thing we covered is Mark Agnafilio wanting to release these nine freak off videos possibly to the public so we can make our opinions about the situation and sway the public to have some type of sympathy for Sean Diddy Combs. And then in another note, we have this BOP investigator just going outside his due diligence, his task or job responsibilities, trying to get dirt on Diddy, thinking that he's helping the cause, but pretty much not helping at all. Like, what? Y'all tell me what y'all think about this. Do y'all think that the defense counsel is trying to get electronic copies to release to the public so it won't be Diddy that's getting ridiculed? It is Cassie. She's having to relive. The whole thing for the protective order is to protect the interest, to protect her. Why does she have to relive this all over again? But it's crazy that they're trying to make it seem as if she enjoyed it. And I spoke about this in the other video. Like, just imagine being in Diddy's presence and you're in that activity and you're acting like you don't like it. God forbid what happens to them at that time. Then tell me your comments on what you think the reason that BOP officer or investigator, why he took pictures when he wasn't supposed to. Y'all let me know in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed. Bye.